We shall now commence with the third session for today on the sub-theme Copyright Infringement and Enforcement Challenges. The media and broadcasting industry is growing rapidly and traversing its own traditional models towards newer pastures. Naturally, new challenges are emerging with such growth. Where the phenomena of internet piracy has grown manifold in the recent times, some contributing factors may be in the absence of limits as to the number of people that a material can be distributed to, ease in distribution of material through the internet, and the difficulty in distinguishing between fake and original works. Two fundamental questions posed in this relation to any IPR administrator are what to administer and how to administer. To further elaborate on these pertinent questions and to discuss today's theme, we have on the panel today Mr. Brijesh Singh. Sir is the Additional Director General for Police in Maharashtra, formerly responsible for Maharashtra Cyber, a unit looking after the cyber security of the Government of Maharashtra. We also have the pleasure of joining us virtually Mrs. Lohita Sujit. Ma'am is the Senior Director, Copyright and Digital Economy at Motion Pictures Association, India Office. Next, we have on the panel Shinoy Prasad, Practicing Counsel at the High Court of Bombay. We are deeply honored to have a panel of revered and esteemed dignitaries amongst us today. I now hand over the platform to Professor Sajid Sheikh, Assistant Registrar Academic, MNLU Mumbai, to kindly lead the discussion forward and engage with our esteemed resource persons today. Over to you, sir.
A very good evening to all the esteemed speakers who are present offline as well as online. This is the gift of pandemic that nowadays we are exploring these hybrid models as well, and the distance is limited in this very manner. So this is the third and the last session for the day, and a very important session. It's on copyright infringement and enforcement challenges, and we have esteemed speakers, one from the enforcement wing, Mr. Brijesh, and another from the production house, Ms. Lohita, and practicing advocate as Advocate Shinoy Prasad. We know that yes, for enforcement and to detect infringement, law exists. There are civil remedies as well as criminal remedies available in the law. In civil remedies, of course, injunctions are there, Marwa injunctions, Anton Pillar orders, John Doe orders are passed. In cease and desist orders are there. And in criminal remedies, punishment from 6 months up to 3 years is there, and of course, fine is also there, which goes above 50,000 to 1 lakh rupees, and of course, in multiple offences, the fine increases there also. So, of course, considering the kind of audience we have in India, not specifically you, I am saying the users, the Indian users, due to lack of awareness, sometimes infringement becomes hyper normalized. We think it's okay. Whenever we search online any music, we'll get like the pirated sites offering music content to be downloaded as on the first search page. So maybe we can have opening remarks on this very question itself. Is IP infringement so hyper normalized? Maybe we can start with the views of Mr. Brijesh, and then we'll go to the specific questions. Mr. Brijesh, over to you.
And the normalization is such that people believe it's nothing wrong to use pirated content, download, transmit, upload. And I would say that there are various kinds of issues around this. That there is a whole mechanism, a whole technological environment which enables this. For example, Google has a Lumen database which basically delists things from search, but that is only after effort. That only when you sort of complain, then effort is taken to bring it down, bring such infringing content down. Similarly, all other such platforms, there are various degrees of enforcement, automated enforcement, I should say, which leads to a clear availability of pirated material. Now, if something is illegal offline, that is illegal online. And in this, you should see that these platforms, be it messengers, be it social media platforms, be it search engines, everybody is in clear violation of law. And I understand that the volume of such material is very high, but technology has made it very simple, cheap and ubiquitous to simply, copy multimedia from somewhere, change its format, upload it anywhere, distribute it to a large number of people, hence normalizing this. And apart from this, there is a slight technical difficulty actually assessing the extent of damage. Like, so let's say one pirated movie seen by somebody, is it equal to one movie ticket lost? Or are we looking at, let us say a number of people not seeing a movie, seeing it on the device, then in that case taxes lost to the government, employment lost to the people who would have, for whom work would have been created, so on and so forth. The other implications of this, plus where is this money going? This is going towards the enabling of this ecosystem. So there's a whole ecosystem which has normalized this, and it's not just the individual behavior. I feel that somewhere platforms should also be responsible.
Rightly said, Mr. Brijesh. But again, talking about the mindset of the user, so I want to pose this question to Lohita Sujit. Is the Indian mindset or general mindset of the people also responsible that they do not take infringement seriously?
Mindset, when it comes to piracy is that, okay, you can't afford a particular kind of content, and there was a study done on user habits in Australia, and they found that the higher the income, they actually pirated more. So I don't think, from a user perspective, it's a mindset. I think we really need more deterring laws, really more action, and to what, Brijesh said earlier. In today's date, we all know that if I have to, approach a service provider, that service provider gets 36 hours, to take down my content subject to a court order which has to be produced in 21 days. So there isn't enough edited. Recently, we saw that the Supreme Court has, said that the copyright infringement is a cognizable offence. I don't know if the penal provisions you mentioned earlier are deterrent enough. So, I think more than the mindset of people, I think there's a lot of effort from the government to have outreach programs, and there's IP training even at the police level now. But I think we just need more deterring laws.
Rightly said, ma'am. Thank you. My again connecting question is to Advocate Shenoy. So, does our law have enough space to allow infringement, rampant infringement, due to maybe incomplete definitions of something like fair use, which allows infringement to happen?
So in that sense, it may not be in that area of concern for particularly the right holders in that sense. But from the perspective of a right holder, you're looking at primarily three kinds of infringement. One is the inadvertent infringement. For example, if I go onto YouTube and I view a clip of a 1 minute clip of a movie which has a, let's say, a funny scene, or let's say a Batman movie, and that is still copyright infringement. It's not something that should be reproduced. It should not be something that is viewed. But I'm sure Warner Brothers has bigger fish to fry than go and see this 1 minute person who's viewing these videos every minute or every second. But there are two other concerns that the bigger players or the right holders may have, even in that sense, everyday right holders. And they are to do with the kind of people who are producing the copyrighted work, reproducing the copyrighted work illegally and sharing it. So these people are the ones that when you talk about normalizing copyright infringement, this is the biggest concern I feel for the industry, because the third, of course, copyright infringement is by end users. That is people who go on to, let's say, websites like Pirate Bay, download movies or copyrighted content in order to view it, because either one, it is content which they cannot afford or don't want to afford. That is, they think that they should not be paying for it for whatever reason it is, or they can't pay for it. And the second part is that for people who, in that sense, own these websites. Like, for example, a good example of it would be something like Popcorn Time. So you see, the thing is that as far as the first person is concerned, we hardly see any action from copyright users in court, copyright holders in court. We mostly see action from the second or third perspective, where you have people who are sharing these, who are actively sharing the copyrighted work and enabling infringement of copyright, or the third one, which is where people are using copyrighted work. I feel as far as the second is concerned, there is a lot of litigation that goes into it, a lot of investment that goes into it, because, right, like, for example, between 1999 and 2015, the US, I think the copyright industry saw almost saw a reduction of almost half the revenue due to copyright infringement, and that's some serious amount of money that is going down the drain for right holders. But there has been a reversal since then, and the reversal has nothing to do with stricter copyright laws. There are enough copyright laws that are already in place, and I feel that there are enough copyright. Of course, there is always a great deal of scope for clarity, even in India, or for that matter outside. But as far as enforcement of copyright is concerned, the question is, are you willing to put in that much money into stopping someone in one corner of the world to stop watching your movie? It does not make economic sense for a right holder to go after one single person doing something in one corner of the world. So what you need more of is, as far as that end user is concerned, because I guess I'll come back to how the industry can deal with the second kind of infringement, that is a sharing kind of investment, that is people who generate and enable copyright infringement. But as far as the third part is concerned, a great amount of copyright infringement has been reduced by making legal content available online. For example, platforms like Netflix, Spotify, platforms like Prime Video, or all these OTT platforms have led to, at least, I mean, I don't have the data for India, but it seems like in the US, the amount of copyright infringement that is occurring from people enabling sharing of, I would rather go to Netflix and watch a movie than go to Pirate Bay and download something and then make it available and then put it on a computer and then again mirror it on my television. So it's just a big amount of, you're highly disincentivizing the end user from normalizing infringement of copyright. The moment you start doing that, you start checking your copyright right there. When you say copyright infringement is normalized, I think the best way to go about it to change that normalization is by making it inconvenient for it to be normal. So that is, I feel, much better than having any kind of enforcement rights, because enforcement costs money. And I don't think anybody here is willing to bear that cost. Not the ISPs, not the government, not the police, not anyone else. The people who have to bear it is the right holders, and the right holders really don't want to spend money on litigation. What they want to spend money on is making better content.
I want to quickly come in and make a few points. I think at least the right holders that we represent, and we also support several other small production houses because of the services my studios offer. We are consistently filing site blocking actions in the Delhi High Court, and it's been a very progressive court for us. Also, British, I would request British to talk about it, but there are arrangements where copyright holders work with the law enforcement for action. Internationally, the advertising the advertising companies assist right holders in stopping infringing action by blockage of ads, etc. So I will urge British to talk about the arrangement with right holders, and right holders do take our interests very seriously.
Yes, yes. Hello. Yeah. Yeah, thank you, ma'am, for this very point. But again, I'll come back to you again on this very question that yes, which Brijesh also raised, the due to availability, lot of infringement is happening, and this was resonated by our chief guest in the morning also, Professor Tabriz Ahmed, that after this digital boom, massive infringement is happening on multiple platforms which are beyond the control with respect to finding out when infringement is happening, where infringement is happening, maybe due to the reach and the servers, etc., are available all around the world. So from the production house side, how do you deal with this very issue of massive infringement, and whether from the production house aspect, whether some measures are being taken to control this?
I'll answer your question in two parts. Let's look at the law. When we are talking about normalization of infringement, copyright, etc., we saw that just in the pandemic, the new normal, there was a loss of USD 2.8 billion, right? And therefore, the measures now have to extend to various parties in that ecosystem. So one recommendation that we have is to have know your business customer obligations within the law. Make it also, some kind of penal provision to look at infringing acts, because that's where the piracy spreads the most, and sometimes honestly consumers don't know what's an app, but the service providers that manage these app stores, right, they need to have some kind of a due diligence in place. Lastly, if you look at the technological protection measures in the Copyright Act, we don't have a clear definition for effective technological measures from an access control point of view. I mean, we do address it in courts through site blocking, but our law really is falling short in that regard. I think a couple of these things combined with, especially what I said earlier, the know your business customer provisions will help deter the problem in the future. To your second question, from a production house point of view, we do have regular audits. So the service providers, say for example, where the post-production work, etc., is conducted, there are regular audits done, and to a large extent, we don't find too many leaks happening at the source. And also, if you look at the camcording part of it, we are hopeful that the bill will pass, because that will have stringent anti-camcording provisions, and I think the government somewhere is also kind of looking at it from a view that everything need not be restricted to a cinema theatre itself.
Right, thank you for your views, ma'am. My question to Brijesh, now I come to him, is about how enforcement agencies are dealing with this issue of infringement, because we have seen recently a lot of ISP, with the help of ISP, they have been blocking a lot of this torrent sites and other sites wherein such excess of sharing this very media is allowed. So are they successful in that very thing of blocking that very excess? Brijesh sir, are you there?
Yeah, there's some slight network issue, it seems.
All right.
I'm hearing you in a race.
Okay, so I wanted to know what is the idea from the enforcement agency side, how they are dealing with the problem of infringement, because law exists, though it appears that some void is there, but law actually exists, and so is law actually being enforced?
So many things. You know, though I share the enthusiasm with which Lohita is exhibiting, but there is also a lack of seriousness on the part of producers towards piracy. I've seen it many times where people are actually happy that their thing has gone viral, and they are not ready to commit resources towards this. Apart from this, it requires a very large technological infrastructure because the volume of things out there is very large. So, you know, to identify something like that, you have to run very detailed crawlers. Then, with these crawlers, you have to pass this data, find out, let's say, based on any metric, based on hash, based on content, you have to identify this material. Then, you know, you have to confirm the legality about this material being pirated. If there is, let's say, a hidden watermark or any mark that you want to identify it for the purpose of evidence, then you have to find it out. You know, that all this is mostly multimedia. So look at the amount of data that you have to process. And this requires a huge technological infrastructure. Apart from that, it requires trained resources who deal with, you know, this kind of fragmentary evidence, with this kind of forensics. Then again, the difficulty of obtaining data from platforms. And nowadays, with anonymization, with encryption, with decentralized networks, I mean, Tor is a thing of past. Today, a lot of this infringement has shifted to real-time platforms like Telegram. Telegram can have supergroups of 10,000 people, and you can have a 2 GB file floating there within seconds with easy download access to everybody. And then you can have, you know, hidden groups where nobody has access to. So the difficulty of finding what is happening. See, Tor is slow. BitTorrents can be tracked if they are not, you know, private. If they are not using private trackers. But something like Telegram, something like Discord, any such messengers, which are real-time messengers, where there is no limitation on the file size, this is happening. And what will you block? What will you bring down, right? Because it's a totally P2P decentralized infrastructure. However, having said that, we actually did a very successful experiment. In fact, I was part of it. We started this unit called Maharashtra Cyber Digital Crime Unit, and it was recognized as one of the 6, you know, significant units across the world by World Intellectual Property Organization. It also went on to win the US IT Champions Award by the US government. Now, what it could do in a short time was that it blocked traffic of the tune of, you know, 400 million hits per month, and it did something very interesting. So we didn't go for kind of legal measures of obtaining, you know, John Doe orders from court. We went for administrative blocking. Like, we approached the authority, and basic thing we started asking them for due diligence of these pirate sites. And interestingly, when we initially used to go on conferences, then you know, all the foreign countries used to castigate us by saying that, oh, your performance is not proper, and so on and so forth. When I realized that only 14% piracy was emanating from India, you know, 16% was coming from outside. So we concentrated on our 16%. We brought it down significantly. Then we went to them and we said, hey, how about Cloudflare? You know, you don't give IP addresses, you don't give any of this thing, you don't comply to any team blocking requests. You don't, and after GDPR, things have become very difficult. That even if you try to get whose data of the host, of where a particular thing is hosted, so you don't even get the domain name registrar, you don't get any of the registered details because it is redacted under privacy laws. So it's you know, fraught with difficulties. At every step there are difficulties. There are problems like jurisdictional arbitrage. So and then obtaining pertinent orders from such a plethora of courts which operate at a very different speed and very different understanding. Having so many resources to follow one case, so it's very easy to make an IP infringement complaint. But imagine the kind of paperwork which goes into it. It's very disproportionate. And that is why the way we emails to everyone. You can't be tracked because there's so much of script rework. Apart from that, you have to track, the legal proceedings in each court, obtain evidence, and for each bit of evidence there is a long procedure. So we took resources, we took specialists, we took even infrastructure, digital infrastructure, drawing infrastructure from the private sector, from let's say bodies like MPA, and we created this unit, which was a highly successful experiment. So I believe that it can be done. There are ways it can be done, but there has to be seriousness on all sides. While there are laws, we may talk about stringent and stricter penalties, but I will tell you something in reality, that the certainty of law is much more important than severity. That maybe let it be a small punishment, let it be a 2-month imprisonment, but if it is 100% going to happen, then piracy will stop. And somewhere there has to be an apportioning of responsibility on the enabling ecosystem. So one small thing, let me tell you that we found that people were making money not by selling content, but by putting it on sites which became so popular that ads would run. And you won't believe that very large banks and multinationals were running ads on that. So what we did, we went after the payment ecosystem. We found out where the payment is being obtained from. We issued notices to, we issued brand advisories to those people who were advertising. We cut the network of payment systems by telling them that, look, this is proceed of crime, you can't deal with it simply. So we went on to do with it. But this is whack-a-mole. As soon as you do something, another digital identity pops up. So it's a game of eternal vigilance which requires large infrastructure, large digital infrastructure, which requires specialists, which requires a legal team, and it requires a lot of effort and also public support. So till we are lacking on all these points, I don't think so we can come up with an effective enforcement action.
Thank you, and sir, very well highlighted this very point that a joint effort is required from the government side also, and from the production houses and all. Then, therefore, in that very manner, we'll be able to curb this very problem. I want to know from Shinoy about how courts are reacting to infringement related matters.
So the courts are pretty proactive. You see something like John Doe orders to recently there was a action by Mr. Amitabh Bachchan where he wanted to in rem, in that sense, has been completely patent all his in that sense, or everything to do with his his voice and his mannerisms and all those things. So I mean, courts are always looking to widen the scope for right holders to enforce their remedies. There is no question about that. But again, we go back to the question, and I think Mr. Brijesh Singh put it really well, that no matter how stringent your laws are, the question in the end remains whether they are worth enforcing or not. Because at some point of time, it's a question of, it's a pure commercial call, whether how much you want to pay or how much money you want to put into this in order to curb end user infringement. I feel you're much better off approaching courts to curtail source infringement, which is curtailing websites that, as my learned friend put it, going to courts for like she said that Delhi High Courts are very proactive in giving you orders, and all of the ones that the orders she's been obtaining are orders against source infringement, which is where you have these sharing websites, where you have these people who share this copyrighted material in order to enable people to infringe copyright. So that's one part of it. But I feel litigation in India is pretty, in that sense, is whatever said and done a little difficult. Like you do get ad interim orders, you do get interim orders, but final orders are very difficult. You'll never see the end of the day for your action. So so we can just look at what other countries are doing in this aspect. Something like the UK, they've got something called the, if I'm not mistaken, they've got the Digital Economy Act, which is similar to our IT Act, where there's a Ofcom, that's the Office for Communication. Now, interestingly, this was never implemented. But the mechanism that Ofcom provided for is to focus legal action on the most pertinent alleged infringers. So if you have a particular infringer, let's say the ISP knows that this website belongs to a certain IP. Okay, let us not look. I mean, I understand, as Mr. Singh said, that obfuscation or obscuring of source is a challenge in itself, and I quite appreciate that. But apart from that, there is something called these in that sense a warning notice or something called a copyright infringement list they were proposing. Now we have that in India for a parallel, if we can think of, is something like the willful defaulters list, where you have people who have taken loans and who have not paid back for 1, 2, 3, 4, 5 reasons. There is a list of them, and no bank ever goes to them again. They will never have loans given to them. They will never have amounts paid to them. Now what happens is that with most sharing websites, you will have to incur a certain amount of cost in order to ensure that you are able to host that kind of material, and you are able to also, in that sense, that make available for yourself that kind of internet services. So there is some amount of money that is in play here. If the ISPs, I understand that ISPs are highly touchy about making them liable for anything. But if the ISPs, there is some onus on the ISPs, or maybe a joint venture between ISPs and some kind of neutral ombudsman that helps identify who these infringers are, gives them, there's something called a 3-strike notice which is used in France, where the first one is sent out with an educational perspective, where you educate the infringer saying that you're not supposed to do this and this is a problem. The second one is a warning, and the third one tells you that your speeds are going to be curtailed for internet speeds, and internet use are going to be curtailed. The websites that you can use are curtailed, and all those things are put into force. So if you have that kind of a list where you curtail access for certain people for a limited period of time, in order so that they don't share such copyright infringement. Another point why this cannot be applicable for end user is because back in the day you used to have a very clear dichotomy between infringement and non-infringement platforms. That is, if a movie is playing in the theater, that is not an infringing copy. If a movie is on the street being sold in a CD, that is an infringing copy. Today, if you curtail let's say you think that there is this bunch of people in this institution that are using copyrighted material, you curtail the infringement of that, you curtail the internet speeds of that institution, you do not give them internet, you're also affecting parallelly legal ways in which they are using your material. For example, curtailing a person's internet will also mean he can't use Netflix or Prime and Spotify or whatever it is. So your problem is that the same road is being used for both purposes, and that is where your difficulty also comes in, and that's a difficulty which you will have to address. But apart from that, I still believe that enforcement of copyright against end users is just too wide. And I don't think that even if you are able to go to court and get orders against such end users, it becomes an unending, infinite task in which you are going to end up spending a lot of money, which is going to be, in that sense, it's just impossible to do. It's much better off to look at the source infringement part and try to curtail that with the help of ISPs and the government coming together in order to see to it that source infringement is curtailed. Once source infringement is curtailed, it becomes very difficult for end users to go and seek copyrighted material, which means that there'll be a behavioral shift to a more copyrighted, in that sense, use of more copyrighted material. And the last point I would like to make is that the use of, in that sense, legal services in order to enforce this. So if there are, for example, if there are mechanisms within, let's say, different IP law firms, which there are dedicated cells that are only doing this, your amount of specificity and the amount of the technical expertise increases, and that is the kind of investment that I feel a lot of these producers and the right holders should make in order to ensure that your copyrighted work is protected, than going to court every time and obtaining orders which you then have the headache of enforcing again. So that is just that's where I would conclude. Yeah.
May I make
Yes, yes.
One is that, as I think the earlier speaker only pointed out sometime before, it's an economic question. So if you remember in the good old days of CD, Mozart came up with this, cheap CD model, where it started directly competing with the pirate, and it made a good market. Similarly, if you look at the model of right from Spotify to Ghana to Apple Music, they are making music very cheap and affordable, which is actually creating a huge dent in the pirate ecosystem. As regards the economy of the pirate ecosystem, see, the money is still paid by advertisement. It doesn't come from publicity. It comes from the sheer virality of that site, and no site is as such sharing material today. So you cannot pinpoint the infringement and, let us say, get an order issued. Most of the infringement is happening on P2P networks, which are very impossible to block. Now, like how do you block a private torrent? So you have no mechanism to block. Or in fact, if something is being shared on Telegram, or even you have things like OD boxes today, which are like a set-top box, which is connected to torrent behind, and then it uses Tor on top of that. So through Tor, it is having a streaming service through which you can access everything. Now this is virtually impossible to detect. So technology is a moving cloud front, and technology can be fought with technology. And here it brings a huge investment. And I feel that industry, while it is wanting to preserve and protect its content, has to come and proactively invest in measures apart from, let's say, digitally watermarking it and things like that, in some kind of a threat hunting. It will have to invest in threat hunting and forensics and, digital analytics for as a countermeasure to piracy.
Yes, thank you, Brijesh. Yes, technology has to be used in order to counter piracy. And since Lohita Sujit has already worked in this very area, has worked with government also, ma'am, I would like to know your views, like what is the role of technology in countering this infringement?
So I think Brijesh has covered, this in his, earlier points. I think it has to really come in from a form of investment by the industry. But I would like to highlight, one of the positive developments that happened during the pandemic. The US passed a law called the CASE Act, and that essentially is in the support of small creators. And they built this mechanism within the Copyright Office, where if you are a small creator and, to what Shinoy mentioned earlier, it's a cost, you can actually go and complain and you get a relief of up to, $30,000 US, between 50,000. So I think the introducing statutory damages in the law will really help, and I think academics should come together to get this instilled. Apart from that, everything else, that Brijesh said is true, and without investment in counter technology, it's going to be very difficult. But I will say that Manafak Studios took a very good action, again with the help of the Maharashtra Police, in capturing the founder of Thok TV, which essentially is, an app you can download, and it will just create an interface where you can watch all your, video on demand platforms free of cost. So that kind of action is always welcome, but it has to come from the industry.
Right, thank you, ma'am. Again, ma'am, a question which I picked from what Brijesh was saying earlier. We see like the media houses selectively enforcing their rights sometimes. Maybe because of convenience, maybe because of the efforts and the money which is involved, and maybe sometimes because it is not worth litigating. So even in the cases where clearly copyright infringement is detected, so from the media house point, would you like to throw some light on it, and whether we can change this very narrative?
So I won't be able to comment on other studios. Frankly, that's not my place. But I will say that the studios that we represent, because they are heavily invested in the Indian market, right? See, today when you're talking about creating content hub of the world, I think they are very serious about protecting what they create, because today what you create in India can be viewed anywhere else in the world because of the sheer reach that your online streaming platforms are concerned. And I think I have not seen any such case is as far as my studios are concerned. I think local studios need to decide the value of their content. It definitely doesn't make sense. And like Brijesh said earlier, nobody's stopping them from coming together as a coalition, investing that kind of money, and working with the police closely to get far more faster action than they would if they went to court. And I think the model that Brijesh led is to that.
Right. Thank you, ma'am. My question to you, Shinoy, is, are the copyright holders, and I am not talking about the big creators here, normal creators, because now is the era of influencers, social media entrepreneurs. So are they vigilant about their rights, and are they effectively using the court mechanism to protect their IPs?
See, a lot of times what happens is that as far as these smaller users are concerned, a lot of the copyright fight is with the bigger copyright holders. For example, a smaller person who's like people who have written stories, and questions of authorship come up, moral rights come up. Those a lot of these people, the biggest recourse they have is against bigger companies, production houses that, in that sense, that do not want to share revenue with these people. And these people are, in that sense, very much protected by courts, because when they are in court, a lot of there's a lot of informal pressure from a judge that, in that sense, to in that, if they are like, let's say there's an author of a script who's come and said that my script was I had sent my script to a production house, and that production house has produced a web series on it, and I'm not being paid. That is the kind of the only recourse that a script writer has is to go to court and ask for an injunction against that production house, and those are given. But as far as the smaller holders are concerned, what happens is most times the smaller holders sell out to the bigger production houses. That is the only way they can put out their work in the bigger world. Of course now there is self-publication and one-hit wonders and all those things, but and Instagram, of course, which of late I've heard that a lot of production houses just recruit their artists from TikTok, where you have 60 or 70 of the top ears users who get into the music industry. But you see, the moment they get into the music industry, those users are no longer concerned with their copyright as much as now the production houses, because now their money, now they've already been paid by the production houses, and now the production houses are the ones that need to enforce the copyright. So it still remains a question as to how much the production houses want to invest into copyright infringement and in courts. And I feel production houses are pretty proactive when it comes to infringement of their copyrights, where copyright is being enabled, copyright infringement is being enabled. And I feel that courts are also very proactive. They've come up with quite a few mechanisms in order to help curb copyright infringement. There are newer and newer nuances. Like, for example, of course, it's been a while now, but John Doe is a very common example of something like that. And that really helps people, in that sense. You don't have to wait for an infringement, or you don't have to wait for a movie to be released and all those things. Nowadays, for every movie, a John Doe order is being taken like a week before the movie is released. So in that sense, yes, I feel that the courts are quite proactive and quite, in that sense, at least at the interim stage of providing immediate relief, courts are very much a go-to in the copyright, for the copyright industry.
Thank you for your views.
Sorry, there's just one more thing you had asked me about, and that was arbitration as far as copyright is concerned.
Yes.
So
Can we think of a speedy remedy?
Yes.
Yeah.
Yes. So I think more and more you see that copyright is becoming a question of licenses and agreements, of assignments and agreements. And the moment it becomes that, it is becoming arbitrable, of course. And when it becomes arbitrable, you're seeing very specialized arbitrators in the field of, if you have a bunch of IP specialized law firms, they are the ones who are in that sense, doing a lot of IP litigation and IP arbitration, and they're coming up with a very speedy remedy for, in that sense, even between intra-production houses. But again, it remains at a very macro level where you have, let's say, for example, a big production house suing another. I have never seen an arbitration where, you have copyright infringement. For example, Netflix is suing one of its users for copyright infringement or something like that, where it is actually it's actually possible for that to do, for a user to do that, to use Netflix in order to infringe the movie's copyright. But you see a lot of copyright, that level of copyright, either copyright action or copyright infringement is not being seen in courts, and not only ours, in any court for that matter.
Thank you, Shinoy, for your views. So we now will be concluding this very session. But again, one view was coming to my mind. Actually, not one view, two contradicting views, in fact. One view is that since copyright, the subject matter of copyright is evergreen. So is the period of copyright, that is life of the author plus 60 years, enough, or it should be extended? On the other hand, another counter view is that this life plus 60 years, it's too much. If you compare it with other IPs, it seems to be too much. So because of which more infringement is likely to happen, because when something for so long is there, it is difficult to control. So I would like maybe we can have view of Lohita ma'am, and any concluding remarks. Yeah.
So term of copyright or the life of copyright should be viewed from a creator's point of view, right? So if you look at any of the big franchisees that you see, most of them came from probably a comic book, and then the IP really evolved over a period of time, right? And in most of these cases, for these brands to become really strong in terms of having theme parks or merchandising, it does take a lot of investment and time. That's the first thing. So I think anything which gives longer protection to a creator should be welcome. The second thing is, if you look at any of your countries, whether it be the US or United Kingdom, I think on an average 80 countries across the world support 70 years. If we do not want to support this as a country, we just not get that reciprocal benefit when that content moves to the other country. So I don't know if that's a really good thing to happen. And there are enough commercial agreements that can be in place if anybody wants to use an IP today. I think non-exercising that is not really the creator's fault.
Right. Fine. Definitely, we should give more points to the creator so that they can exploit their creativity more. Last view from Brijesh. Since you talked about the model at Maharashtra level, this digital cybercrime unit, is something on a national level or international level be thought of, wherein this joint partnership can be there in order to curb this very menace of infringement and effectuating the enforcement part?
I think the Maharashtra model is something which can be followed across the world, because it basically created a collaborative model where you were enabling each other. So law enforcement, where it was lacking in strength and expertise, the industry was coming and providing, even intelligence. Industry where it was lacking enforcement teeth, law enforcement was providing the enforcement teeth. Like a notice going out with the authority of law from a law enforcement agency which is investigating something. It also led to a kind of enhancement of knowledge on both sides. So let's say our investigatory practices were enhanced by knowledge from the user, and probably the industry also benefited with understanding how law enforcement functions and can function. Also, then the sheer question of who will finance it. So it created almost, I should say, a layer where industry was financing it not per case basis, but it created a common pool where anybody who's unprotected also who can come and avail of these services. We were very clear since the beginning that we cannot create a pay-per-use service because we are law enforcement. We will not be able to say no to anybody. So it created a nice model which showed that how industry and law enforcement can collaborate on strengths and then learn from each other. So it's a good model. However, across the world, if you really want to tackle the question of piracy, you'll have to come together with a slew of awareness, technology, legal measures, plus some very sincere effort and investment in this whole field. Thanks.
Thank you. One last view from Shinoy about whether there is a need of like an agency, just like we have of WIPO Arbitration Mediation Center, maybe some agency in India wherein which can play the role of a mediator and settle the disputes, because not everyone can go for arbitration, not everyone will go for litigation. So what happens sometimes they just let go. So whether some agency can be thought of.
I think it is quite a great suggestion. In fact, we have seen that with something like the NCLT, where you had the whole recovery mechanism now is very quick, and you have a bunch of people who are in that sense it's only things that are not disputed. Those are the cases which are seeing very quick orders and quick recovery. But that said, there is a very clear incentive in the NCLT for banks and the government in order to establish that organization. The question is, does the present government, or in that sense the present copyright holders, have the incentive to invest that kind of money into setting up a mechanism like that, both for investment and both for enforcement, that is obtaining orders, and for eventual enforcement of copyright. I understand 100 crore loan wanting to be recovered. You're paying your lawyers, they're going there. You have a whole investment that the bankers are made, that the creditors are making in order to recover that money. But what if that is the kind of money you need to spend on making sure that you have, there are the lawyers engaged and that orders are obtained in that court. Whatever said and done today, you have to also balance it with the rights of the people who are using that copyright. There has to be an adjudication that there has been an infringement of copyright at some point, because you cannot enforce a right without adjudication. And if you are not going to, who's going to pay for this adjudication? The biggest problem that today we are seeing is that nobody is willing to shell out money. Everybody wants their rights enforced, but nobody is willing to shell out the money for it. And that is the long and short of it, because in the end, as Brijesh said, there are so many mechanisms and so many ways of curtailing this, but beyond a point, it's the copyright industry's commercial call to take that if I want to stop copyright infringement to this extent, does it translate to money coming in for me? I understand the moral turpitude behind it of saying that nobody should infringe copyright, but in the end it also ends up being a commercial balance, and that's a commercial balance which the copyright industry has to draw. That's the question. And if it draws in favor of having a body like that, then I think the body like that will only help, of course.
Thank you for your view, and with this panel discussion on copyright infringement and enforcement challenges is over. And I must say, and I must thank all the panelists. It was a great panel, great discussion. Thank you. And definitely we'll be taking it forward as well. Thank you all.
Thank you.
Questions? We can take questions, I think.
Maybe since Lohita is here, maybe she can answer as well. I think, I've been looking at this. Lohita knows, for quite some time we have had these discussions. I was also involved in the discussion with Brijesh's team on, taking things forward. Are we sort of concluding that ultimately when you talk about, one is the infringement which is of civil nature between two parties which are identifiable, trying to get, damages and all of that to be, sort of litigated, and as Dr. Saraf said in the morning, in the Indian courts it becomes really tedious to reach that stage. But when you are talking about online piracy, which is, willful, that kind of piracy, are we saying that just blocking the websites is the ultimate remedy that we are looking at? Or are we saying that we are looking at, as you said, money coming in? Now, when you say money coming in psychologically, if I'm able to stop, piracy, maybe I'm not losing the revenue. That is the way I'm thinking that money is coming in, or actually seeking the damages. For example, disclosures of ad revenue that you have made in some forum, and then trying to get that revenue back. The related question to that is, because we have also noticed that a lot of these pirate, the origination may be outside the country.
Yes.
And we have had these situations where our own clients, located outside,
Yes.
they are under legal restrictions from disclosing
Yes.
information of their own, citizens. If it is in India, maybe they can be persuaded, but because of MLAT and all of that, it takes a long
yes.
time to sort of get that information, right? So that's why I come back to the point, is the blocking is the real remedy we are looking at, and then the John Doe. Then the related questions, I know it's a multiple questions, but so that, you can sort of look at this. I was told by some of the producers that going for John Doe continuously to courts for every film, as you rightly said, becomes also very time consuming and also, costly. So is there a legal, simple mechanism that we can work out, which is quasi-judicial as suggested by Delhi High Court also, where you on the one hand take care of this blocking, but on the other hand also figure out, is there money coming in, or that is a done deal that we are not really thinking of money coming in. So just connecting all these points, if I can have your views, both of you. Yeah.
So on the site blocking initiative, what we have done is, we've kind of managed to secure a dynamic injunction. So, you may go in with a list of websites, but anytime if there's a slight domain name change, because these websites are viewed by the court as flagrantly infringing, that has kind of, expedited the process. And I think that should continue. I mean, if there are John Doe orders, there should also be these kind of, injunctions also that should be sought from the court. I clearly, I really want to advocate two things today, and also because we have some esteemed academicians. Somewhere we have to see that, the IPAB was abolished, right? And now all cases are going to different courts. And I think the Delhi High Court, being the first High Court that has kind of dedicated intellectual property division, I think, sir, there can be some kind of a mechanism where all infringing cases are decided by one court. And of course, there are many other issues when it comes to licensing. We never spoke about it today, but like nobody is thinking today when it comes to any kind of statutory licensing or compulsory licensing issues, there's no IPAB, right? So it's going to literally commercial courts across the country. So to Gauri's point, I think it's a matter of doing both, but any kind of industry coalition, coming together, working with law enforcement, working with the advertising industry is welcome.
I think to just understand your question, the question that you were asking is that today, as far as this alternate mechanism is concerned, today we are looking at courts and going to courts and taking up that money and using, both time and money, and having to enforce the right that way, and whether any alternate this is possible. I think that's actually a very proper suggestion, because I think that is the only way forward. Because if time and again you see if the kind of there are two things to this. First of all, one is adjudication of your copyright, and the second is the enforcement of whatever that adjudication is, right? So now, if we are going to take so much time in the adjudication of it, and if it's going to be so cumbersome to adjudicate and say that yes, you have a copyright which you may enforce, then the enforcement of it remains one more tedious task, which in that sense copyright holders have to burden themselves with. So I think there has to be some kind of a mechanism where it's, I think the only thing that comes to my mind right now very readily is some kind of an ombudsman, where you have people who have, and the ISPs have to be a big part of this, where you have people who are sharing these websites, and see, the copyright infringers are many, but the ISPs are still not, I mean, still you can still have an account of them, saying that, look, these are the ISPs. So if the ISPs, there is at least, if not, look, nobody is saying that the ISPs have to have criminal consequences for not discharging these obligations, but if the ISPs are at least obligated, even if not to disclose, because as your disclosure problems are there, I completely understand that ISPs cannot disclose. But as far as ISPs are concerned, they at least internally must address this issue of going to those users and saying, look, there is a problem. We have received a notice from the copyright holder. We are protecting you this time. We are protecting you twice. We protected you thrice. Whatever number of times in a period of 3 months, 6 months, 1 year. And if you are beyond that, we are going to put you out. And the way you put you out is that the ISP comes and discloses it to this body. Let's say it's a tribunal or whatever it is. And the tribunal decides whether, okay, now this body needs to have its rights curtailed by curtailing the use of internet for that body or that person or that entity. And that has to be a cross-jurisdictional arrangement, where if there is such an order from a body in, let's say, England, then it will be enforced in India. Of course, China is a wholly different ball game, but it will be enforced in India. If there's an order from India, it will be enforced in the US, and that is the only way to go, because I mean the borders are only territorial. I mean, if the moment you get into the internet, there are no borders. There is nothing. So you see that with the crypto industry also, and that's the biggest problem that the crypto industry is facing today, as to how do you, someone sitting in the US hacks a wallet in India, what do you do? What kind of orders do you obtain? Who has jurisdiction, and where do you enforce whatever orders you get? And who is this person who you are going to enforce it against? So if all of these problems are going to be, your first headache is going to be, do I have copyright? Then that's where, I mean, a lot of copyright holders will be just disincentivized from, in that sense, enforcing it. So I think if these mechanisms are put in place, and in that sense also there are specialized branches within a law firm that handle this. It's like, for example, I've seen that most commonly in SAT. For example, it's like securities litigation, where it's a very clear kind of, where a branch of the law firm is just dealing with SEBI, and it's a very, SEBI goes and you argue before SEBI, and it's, people said, SEBI would always take a view which is for them and against regular, would never be with a infringing person, but that is not true. Day in and out, SEBI is passing orders which don't necessarily hurt the person who is claimed to be infringing the regulations. So if you have those kind of mechanisms where there's clear licensing between the copyright holders and this organization that she's which is like something like SAT or whatever it is, and through specialized channels which I feel have to be lawyers or legal law firms, it really helps set up a mechanism which will speed up and especially law firms that have cross-country presence. It really helps, where if you are also in the country which is where the infringer is, or where the source of infringement is, and you are in the country where you are, where this copyright holder is, it really helps you branch a lot of, it creates a lot of, like conduits which really help for easier infringement of copyright.
I want to add something here. See, blocking access to the users is the first step which is required if we have to minimize the infringement. And if the access will be inconvenient, like ISPs blocking many torrent sites, many other sites which hosts infringed content, definitely people will look for alternatives. And what we have seen in India, in recent years, OTT platforms have got a lot of acceptance. It was difficult to imagine, like 7 to 10 years ago, that people in India will be actually purchasing multiple OTT platform subscriptions. But now, yes, that is a possibility. So I think something like that, technological measures, if we take, that is always better, because when there are multiple jurisdictions involved, as sir said, it will be problematic all the time, for the enforcement agents.
There's just one question, there's just one point that she had raised, that are we talking about money that is from the websites, or are we talking about alternate economic benefits? I think it would be the latter, that is alternate economic benefits, because there's a lot of research in the US currently happening on it as to what the effect of these legal avenues are on simply a change in this whole dynamic. I feel as far as getting money from these people are concerned, we litigate in courts where there is a human being, we know that there is a contract with that person and it is breached. We don't see solutions for years and years together. I mean, courts are highly overworked and are under a lot of pressure to dispose of things at the interim stage. So getting money out is, I think that's a parameter which I think the copyright industry should just not work with. I think you're much better off thinking that, how do I curtail this copyright enabling platform, a copyright infringement enabling platform, and I go for and I promote a copyright using platform and get a behavioral shift between these two through, of course, stricter enforcement and things like that. That's about it. Thanks.
Any more question from the audience? Yes.
My name is Rajendra. I think this was a great session and first time happening in our country. I have not heard this kind of program happening anywhere in the country, so kudos to the organizers. My question is little initially different, but then I will come to the specific ones. As a country of such a vast country, 1400 million Indians, all of us are creative. With mobile in hand, we can be highly creative. So problem one, we are not creative enough. Everybody is not creating copyrightable matter. So that is the main problem. The other part is we are not commercializing. In patent also, now we have started lodging some patents. There again, the foreigners are lodging more, and we are not commercially using that. Copyright as part of IPR was always in silo. It was sitting in Delhi somewhere, etc. So it was not part. Now it has become part in last couple of years. So the issue is like this, which I have in my mind. Consumer law has initiated and all civil disputes go through mediation first. The process of lodging a complaint is very easy. You can do it on internet and then it is lodged, and the offices have mediators attached and the problem goes to them. If it is not resolved, then it comes back. So for civil disputes, if we raise, today copyright is nothing but cinema and some successful books, etc. And cinema is also not successful. Out of 1,000 movies we create, perhaps 900 bomb. They don't make any money, right? So what is the copyright over there? Because commercial value is not generated by the producers themselves. So coming to this, so mediation could be a great option. And this is an institution where we are sitting and we are, I think also we are making kind of recommendation, etc. So Consumer Protection Act 86, that has been now completely overhauled. A new act has come, Rule 2020. And there we have the commercial part or the civil part taken care of. So why not we have that kind of thing? The second part is the criminal part. India, we have about 152,000 police stations. And I challenge anyone, please check, section 63 is not properly known even to the SHO of 10% stations. So what the hell we will do? Are we talking about Bombay-based copyright issues? What about the villages? 5,96,000 villages. People can be creative over there because mobile is there. They can create entertainment, they can create any kind of a story, etc. And we have so much of folklore over there, so we can bring that. So we are not bringing that, right? So police is not aware about it. Some issues come and there are some very, very competent people. For example, Mr. Brajesh Singh, he has spent 25 years in particularly this area. So such people are rare, they can educate others. So, three problems. A, we should create more copyrightable material. We are not creating copyrightable material. We are not copywriting our work. That is a part. That is a major problem. And we are not commercializing that. That is the second part. Because if there is no commercialization, what law we will implement, what law we will create? That is a part. The B part is the civil part. And every small individual should be empowered to protect her or his copyright. A, the person should be aware and should be able to defend and prevent others from using the copyrightable material. Maybe it is a parody a person has created sitting in his or her house, etc. And the other part is the police part, the implementation. And today, after IPAB has gone, commercial courts have not come into being, and it is impossible for a common person to go to High Court and get a matter readdressed unless you have very competent advocates who have been paid enough to run after your matter. Otherwise, you can't get anything done at any High Court, and that will prolong for a long time. So, a few problems which, as a common people, we are associated with, and also the remedies in form of civil and also the criminal ones. And Section 63, you can check. You can call, police station numbers are there. We can call in 2-3 days time 10 numbers in Tamil Nadu, in Uttar Pradesh, in Kerala, in West Bengal, Assam. They would not know what the Section 63 is. That person knew only 66A, in which 7,500 FIRs were lodged after Supreme Court had read down that section. After that, people were lodging left, right and center. They don't know anything. They don't know 43. They don't know 67. They know only 66A. I don't know if today also people are lodging FIR and people are put behind bars under Section 66 capital A. So the problems are commercialization, copyrightable material we are not creating, and the civil part, commoners, and criminal part, commoners. A lady who has created a song, she should be able to defend her copyright, a civil as well as a criminal. That part is not happening. We are concerned with Ajay Devgan. He has got money. He can get 10 lawyers. Rohit Shetty can get anyone and get the matter sorted out. But what about the balanced people? That is the democratization. Mobile has made everybody empowered, aware. But are we really democratizing our intellectual property rights, particularly entertainment and copyright? So that is my issue before an August panel. Thank you.
So,
You are referred to China sometime
yes,
back.
yes.
So I have visited twice China and I have seen both things there, genuine goods and fake goods, standing across the road, both shops. How they are managing to run the show globally, and the power, global power also, is the economic might is right there?
Well, a lot of times what happens is that as Mr. Brajesh said, there is this whole trend of viral videos. China has numbers more than economic might. So so a lot of times a copyright holder, for example, let's say there's a person on
All IPRs.
Yes, all IPRs, TikTok, or let's say trademark holder, or let's say let's say the person puts up a video on YouTube. Okay, let's say I put up a trailer on YouTube. As a producer, I put up a trailer on YouTube. Whether that trailer is viewed in India, or it is viewed in America, or whether it is viewed in China, a view is a view. And in the end, I can boast of 10 million views or 12 million views or whatever it is. So, there is also, so if there is a bunch of people in China who are viewing that, they are happy to let them view it, because in that sense, your movie is getting that kind of that kind of traction. But that again is viewing of this material, copyrighted material, and which is legal. So the line between the two is sometimes, in that sense, is there enough incentive for a person to go to China and go and have that enforced in China, while rubbing a lot of, like you said, economic might, while rubbing a lot of feathers the wrong way? It does not make sense for that person. He'll say, okay, one country I am getting certain amount of infringement out of it, I'm getting some amount of benefit out of it. It's not worth my headache to go there and enforce this. But in a country where legal enforcement is more readily available, like India, or in that sense Europe, you will want to enforce it and see to it that you maximize the amount of your the enjoyment of your right, and that's where the cards fall. I mean, pieces fall, and I think people accept it with China. That is where things are going to fall, and you let it go. That's all you can do.
All right, so we had a fantastic post-panel discussion also. So thank you to all the speakers once again.
Thank you so much.
Thank you.
Thank you, sir. May I now request Gauri Godfrey ma'am to kindly felicitate sir with a memento and a sapling. We would also like to thank Lohita ma'am and Brijesh sir for joining us virtually for the panel discussion. Thank you. Request Gauri ma'am to kindly deliver the closing remarks for today's session.
Thank you very much. First of all, on a Sunday we have had these discussions. I was out in the mountains for 2 days, and thereafter to come and sort of get into this heavy conversation was very, very engaging. I think the one of the key purposes, and in fact the way the conversation started was we were at FICCI event where Justice Pratibha Singh was making her opening remarks, and she had suggested several things that we should consider in the context of enforcement of IP, and thereafter Sajid sir approached us to sort of organize this discussion, and especially in the context that DPIIT cell is attached to the college. So as lawyers at Nishit Desai Associates, we are always, we have three purposes. One is of course doing best client work. Second one is to create socially conscious lawyers. So one of the key things is to do student education. So that is why I told Sajid sir that YouTube viewing should be available for this, and later on also this will be available. And third one importantly is to sort of work on the future of law. So that is the other purpose, that's why we were constantly looking at, okay, what does it mean? We can't just discuss the issues, but what is the takeaway for us? And we plan to, with your college basically, and with the industry sort of inputs that you may want to give in addition to what we discussed, at least identify 3 to 4 key areas where the law should be revisited, whether it is Copyright Act. Now the government is working on reworking of the Information Technology Act 2000. They are looking at new Digital India Act. So whichever legal tool that we want to use to sort of address these issues, we will be creating a report to present to the government. So anybody has any additional comments, please feel free to let us know. You have our IDs, and we will be working on that shortly, and we will circulate once it is presented to the government. So that is the sort of main purpose of a workshop, because sometimes when you do a seminar, discussions happen and then people go home, right? But the purpose of this smaller workshop is to sort of have more engaging conversation and have certain takeaways. So thank you all. Thank you MNLU for sort of being part of this endeavor, and we will be constantly working with your team to take these things forward. And thanks to all the panel members in whoever is present here and in absentia. Thank you all for contribution. And the last thing is to the students, whoever is going to listen to me, that always sort of look at law as not just what it is, but what it ought to be as well. So always think on those lines, and just don't study law for just interpreting what is today, but also look at what are the legal solutions that the law can provide. So and work towards that as well in your profession, maybe not initially but later part of your career. Thanks a lot, and have a good evening.